Honourable David Parker.
Thank you, Mr Speaker. My question is to the Attorney-General. Does he agree with Colin James's assessment of his handling of the Marine and Coastal Area Takutai Moana Bill that, quotes, "Yet again the government, pale shades of the dark days of Sir Robert Muldoon, has discarded constitutional niceties, this time for expedition. Not a good look for Mr Finlayson, who, as Attorney-General, is the Cabinet's guardian of constitutional propriety."
The Honourable Chris Finlayson.
Mr Speaker, no, I don't. Mr James was talking about the work of the Maori Affairs Select Committee. As a member of the Executive, I have no responsibility for the Select Committee. That committee reports to Parliament. It determines its own processes. Nor do I have any responsibility for its excellent chair, Mr Henare. On the point of constitutional propriety, I can tell the member I take my duties very seriously. For example, I've produced reports under Section 7 of the Bill of Rights Act, a constitutional requirement the previous government ignored in order to ram through its universally reviled electoral finance legislation.
The Honourable David Parker.
Does the Attorney-General agree with the Nelson Mail editorial of 12 February 2011 that rushing the Marine and Coastal Bill back to Parliament, quotes, invites nothing so much as despair? It provides even more ammunition to those who have argued that the new law will fail abjectly in healing the festering sore which has opened up since the seabed and foreshore issue was sparked into life the best part of a decade ago. It reinforces the sense that the bill has become a source of inconvenience for both National and the Maori Party.
The Honourable Chris Finlayson.
No, I don't, and actually I read that editorial when I was in Nelson on Saturday night and reflected on it. I think that the author of the editorial hasn't read the legislation, because what the legislation endeavours to do is restore two things that were taken away by the previous Labor government: access to justice and respect for property rights. And it took one very brave person, Mrs Tariana Turia, to stand up to Helen Clark, and the aim is to put it right.
The Honourable David Parker.
When the Attorney said last week the Select Committee Chair was efficient in bringing the bill back to the House 2 weeks early, which decision does he consider most efficient? The decision to prevent members of the committee from seeking legal advice relating to the effect of the bill? The decision to prevent members from making amendments to the bill? Or the decision to prevent members from being able to properly consider officials or advice, or the over 4,500 submissions received?
The Honourable Chris Finlayson.
Mr Speaker, I think when the member turned up, which I understand was in occasional circumstances, the chair conducted himself with propriety. He was a tough and demanding chair, and one needed someone like that to get through the huge number of submissions and get the bill back to the House by 25 February.
Point of order?
The Honourable Clayton Cosgrove.
Sir, could you advise me...
is this a point of order?
It is a point of order, sir.
Point of order, the Honourable Clayton Cosgrove.
Could you advise me? I thought it was a long-standing tradition that members could not refer to the absence of members either in this chamber or in a select committee, which is a part of this process. And if I am correct, I'd invite you to explain to the House why you did not pull the minister up.
The Honourable Jerry Brownlee speaking to the point of order.
Yeah, Mr Speaker, if that was of concern to you as the chair, and I'm sure if it was inappropriate it would have, then you'd have pulled up the Labor Party previously for mentioning the absence of a minister.
That's right. Yes, you did.
Order. I think we can get too pedantic about these matters. The reference was very much in passing relating, and I think one's got to accept the nature of this question is highly political. The question is not particularly seeking a lot of information, it's making political points, and the Minister is perfectly at liberty to make political points in response. There's no way I'm going to stop him from doing that. Point of order, the Honourable Clayton Cosgrove.
Accept your ruling. Is it therefore the case that the Minister can, in making political points, allege a member's absence when that is absolutely not true?
Order, no. The Minister, in answering a highly political statement like that, can be political. And I'm not going to get too pedantic in preventing that. If members don't want ministers to get political answering questions, there are some questions on today's order paper that are good examples of questions where I've stopped ministers from getting political. But if questions are asked that are highly political in nature, answers can be expected to be political. Is there a further supplementary question, the Honourable Shane Jones?
To the Attorney-General. Why has he refused to comment, explain and identify the size of the political slush fund to fund Takutai Moana litigation as announced by Dr Peter Sharps?
The Honourable Chris Finlayson.
Because there's no political slush fund. Under the 2004 Act, as Mr Jones should know, there was a fund set up to deal with certain types of application to the High Court, and that is a fund which after 6 years there's about $215,000 left. And we're not concealing anything, I say to Mr Jones. We're trying to deal with the issue of what to do with that fund under the new legislation. It is certainly not political hush money for the Maori Party. I do wish he'd get himself under control.
Question number 9.